Hello, everyone. This is another episode of the Unisolve question. And today I have a special guest that I wanted to meet with for a long time. She is a legal communications guru, legal writing guru. Her name is Caroline Mandell. Hello, Caroline.
Hi, nice to be with you.
Very good to have you. So, Caroline, you're not just a pretty well-known legal writing guru. You also teach judges how to be judges. Is that correct?
Well, something like that. I teach decision writing, and of course, part of decision writing is decision making and the process that you go through to come to a decision and then to be able to explain it.
So, what is the platform that you use to teach judges?
So like everything in the past couple of years, all education has moved more or less to Zoom. So I do all of my teaching for judges and also a lot of teaching in the tribunal community. So a lot of work with adjudicators. We do it all on Zoom now, but in the past and hopefully in the future, we'll be able to be back together in a room.
Is that part of the Canadian Institute for the Administration of Justice?
So that the CIAJ does have a basic decision writing program. That's not something that I teach in. And then there are other courses that are offered through the National Judicial Institute, again, through the CIAJ. And then for adjudicators, there are also all sorts of programs, one of which is offered by the Society for Ontario Adjudicators and Regulators. So there's a lot of different options out there for people who want to polish their decision writing skills.
I think you're a very important person. So the abbreviation is VIP, and anyone who teaches judges or adjudicators is a very important person in my view because of my profession. I want to get slowly to how you became this VIP, this very important person that obviously has a lot of influence on our system of administration of justice. And I want to start from the very beginning. Where are you from, Caroline?
I'm going to, just before I answer your question, I just have to tell you how gratifying it is for anyone to say that anything I do right now is important. I have teenagers, and nothing brings you down several pegs like having teenagers. So thank you. I think I might dispute the position that you're offering, but I appreciate it. So I'm from Toronto, and I went to school in Toronto through Olive University and through law school. I did a combined master's degree in international relations and my JD in the first year that they switched over from the LLB to the JD at the University of Toronto.
Where in Toronto did you grow up?
I grew up not far from where I live now. I grew up in Cedarvale.
Okay. And I also have a master's in international relations just to show that we have some common ground. Why were you interested in international relations?
Well, so I'm interested to know why you, and do you find that you use that background at all in your litigation practice?
Only on Twitter when I argue with people about international. Well, I don't even really argue about international news anymore because that's fraught with peril. But I don't. You know what? I don't use my international relations training at all, except when I feel deep sense of sadness and regret about international news coverage. And I just compare the way they cover it with my training, with my knowledge, and I just feel like it's not good. But that's really the only time I use my international relations training. What about you?
Yeah, it doesn't come up as often as I would have thought it might. But any time that you sort of learn a new skill set, you find yourself drawing on it in unexpected ways. I pursued international relations because I think it's partly a product of when I went through university. So I went through university in the late 1990s, and it was a really exciting time. And there was a feeling that there was a sort of, dawning of new, renewed sense of the importance of international institutions. That was the sort of the Axworthy doctrine, if you remember back to the idea of human security and that borders mattered less than people. And so I wasn't actually sure where to take my education. I am a first generation lawyer. I didn't know any lawyers, so I really didn't understand what that meant. And I understood law school to be sort of like intellectual finishing school, not actually as a trade school. But in near the end of university, I took international law from now Justice Ed Morgan. And within a couple of classes, I went, oh, I see, I get it. So law provides this really rigorous framework for me to examine these questions in. And so I thought I would actually pursue a career in academia and sort of, I guess, hedging my bets or doubling on the fun, however you want to look at it. I did that double program and found very soon that because the way it worked was you did your first year of law school and then you did the master's and the rest of the JD concurrently. I just fell very, very deeply in love with the study of law. I don't know that there's a lot to love about first year law, but I did, which was unexpected. And so from there, I was really hooked and just pursued that direction.
Did your parents steer you at all in your educational choices and career choices?
Really, I would say that they steered me to the extent that there were always books in the house. The news was always on. We got 2 print newspapers a day. And I grew up with the sort of deep-seated idea that it was a responsibility to understand what was going on in the world around you, locally, nationally, internationally, and to be curious. So I definitely didn't get any pressure about a profession, a particular profession in one way or the other. And my sister and I went in quite different directions in our careers, but it was important to have a broad perspective. And to this day, I think that, it is the responsibility, part of adulting. I don't like adult as a verb, but to the degree that that's ubiquitous, and so I'm going to just go with it, I too adopt the idea that it is your responsibility to understand what's going on in the world around you, and not just to be getting your information from, your very narrow cast view of whatever's coming up on your social media feed, for example. And I hope we haven't lost that in this next generation. I worry sometimes.
I always look for parenting tips. I have a preteen, so I'm looking forward to that teenager experience that you just mentioned in the beginning of this interview. How do you imbue your parenting with this perspective? How do you give this broadness of perspective to your kids? I assume you have more than one.
Yeah, so I have an 11-year-old and a 14-year-old, and I will be honest with you, I find it very confusing. Not to say that the world that we grew up in was simpler, it wasn't, but I think that there's something profoundly destabilizing about the moment that we are in, where children cannot necessarily trust grown-ups to make decisions that are good for them. I don't want to get too political, but to be raising children when their sort of political awakening happens in the era of Donald Trump being the president, right? And seeing that as sort of the apex of political and moral leadership is very challenging, because you have to sort of explain that this is not normal. This is not how adults behave. We don't act in, completely brazen self-interest. We have to consider our neighbors. And then to extend that into the pandemic is also very challenging. As we record this, it's the weekend where healthcare workers have been told in downtown Toronto, when you come into work on the weekend, dress in plain clothes. Don't dress in anything that will identify you as a healthcare worker. My husband is a healthcare worker. And I find myself and I don't know that this is the right thing to do, but I find myself shielding my kids from the news more than I find myself exposing them to it, because it's so hard to wrap your head around that idea that you are in danger for doing the right thing. You're in danger for just doing your job. So I don't have a good answer for you, I'm afraid, but I do, we still do get a newspaper delivered to our door every morning. I leave it out on the breakfast table. And so, you can't tell kids what to do. You can only model what you hope that they will pick up on. And so, in those subtle ways, I hope that we're imparting those same lessons.
I hope we can continue the parenting conversation later. I'm really fascinated. But back to your legal path and legal career, you found your way to where you are through working for the government. And I'm thinking of another guest, Julia Henningsberg, who also took a similar path. And I see some parallels. You also worked as counsel at the Ontario Ministry of the Attorney General. And my question for you is whether that experience now in retrospect was a prerequisite for where you are now. Do you need to work for the government? What did it do for you to get where you are today?
To be mentioned in the same breath as Julia Henningsberg, and I don't even think she knows this, is so exciting. And I wish that the me of 20 years ago or so could know that that was going to happen. I admire her so much, and it's not an accident. So Julia was, working in government at a very high level when I was in law school and figuring out what I wanted to do. And her husband, now Justice Dawson, was a really important mentor to me. I should mention that his mother was also my grade 3 teacher. So I have had the privilege of being taught by 2 generations of Dawsons. And I think this is probably less true now, but it's certainly true that at the time that I went to U of T Law, there was a real conveyor belt to corporate, to Bay Street. And, those opportunities were, definitely available to me. And I summered at one of the Seven Sisters. I had a good experience, but I knew that I wanted to work in the public sector. I knew that was where I wanted to end up. And there's some strategy involved where if you know that that's where you want to end up, when I clerked at the Court of Appeal for my articling year, you end up in the higher back pool for government jobs for a period of time. And so I decided to stay in the public sector because that's where I wanted to end up. And so I did that first job at the ministry, and then and really my dream job was to get back to the Court of Appeal somehow. There's at the time there was a quite small handful. There's now a larger sort of 2 handfuls of staff lawyer positions at the Court of Appeal, and within 2 years or so of having clerked at the court, I was back in a staff lawyer position, and I was there for over a decade.
Yes, you clerked at the Court of Appeal, and then you started the longest gig in your career. You worked as legal counsel at the Court of Appeal after your government job. You were legal counsel at the Court of Appeal for more than 10 years. Explain this role. Do you give legal advice to judges? Do you help judges prepare judgments? Please talk about that.
So the staff lawyer position at the Court of Appeal sort of entails 3 main buckets of work. One is to support the work of the justices on cases, and it tends to be bigger cases that require, more extensive pre-hearing work, post-hearing research. Often the staff lawyer will work with the judge's clerks, but the clerks are, usually working for more than one judge at a time and will rotate out after 5 months. So to the extent that something is going to sort of be under reserve for a longer period of time, that's something a staff lawyer would often work on. And the staff lawyers also identify those cases that are coming in that are unusually complex and or have jurisprudential value. Those things do not necessarily overlap, but often they do, because the staff lawyers are getting sort of the first look at cases on their way in. When appeals are perfected, the staff lawyer takes a first look at the appeal to assess how much time for oral argument is required. I should say, this is how it used to work. And so I can't speak to how things might work now, and especially how they work in COVID times. And then, of course, that time assignment gets reviewed by a judge. And then the staff lawyers also at the time, and I'm not sure if this is still the case, would also review applications for leave to appeal. And again, sort of, assist in getting those cases ready to go to a panel for a decision. And then, lots of support in editing judgments. And also, there were sort of discrete projects there where it was helpful to have additional support from somebody who was a lawyer. So I had the great privilege of working with Justice Mark Rosenberg on the mental health appeals, what was then called the amicus program for appeals from the Ontario Review Board, which were time sensitive. And in later years, also assisting him on the fantastic and valuable inmate appeal duty counsel program.
When you mentioned Justice Rosenberg, you made me think of Marie Henon's book that I recently read, and she talks a lot about him there in that book. You spend a lot of time at the Court of Appeal. You, I think, know more about the Court of Appeal than any Canadian appellate lawyer. Appellate lawyers interact with the Court of Appeal through a very set interface. It's like almost like a black box. There is an interface, there are buttons, there is the protocol, but you are on the inside. And the second part of this is that you day to day worked with some of the smartest jurists in Canada. When I first made up my submissions in the Superior Court, so I just want to talk to the quality of our Superior Court judges, I was blown away by how sharp the judge was, by how immediately they identified the issues and what matters and what doesn't matter, and just steered me on the right path. That was years ago. You were in that environment all the time. So what effect did it have on you? What did you learn from them? What are the most important lessons you learned from that cohort of the smartest people in the country?
I think you've put your finger on it. It's, what the best judges can do. And I saw it, over and over and over again at the Court of Appeal, in different ways, because every judge approaches their work slightly differently, was it's as if a judge has a pair of X-ray glasses and they put on those X-ray glasses and they just get right to the heart of the case, right? And it's stunning. And I saw it many, many times, sitting at the back of courtroom 1 or courtroom 10, seeing a judge just, within the first 5 minutes of somebody getting up on their feet, asking the one question that the entire appeal turned on. And you'd often see, quite experienced counsel sort of, take a minute and you could, they wouldn't say, I hadn't thought about it that way, but you could sort of see, well, oh, gee, if I had seen it that way, that's exactly the point. And so I think it's first and foremost really important to see your case through the judge's eyes, right? Litigators get a lot of advice, and it's good advice to see the case through the eyes of the other side. There's this famous story, may or may not be true, of a grand moot at U of T Law School many, many years ago. And I don't remember which judge it was who told the students when they got up to argue the grand moot, switch sides. right? Because that's the skill of a really good litigator, is to be able to see the case and to be able to articulate the best arguments on the other side. Very, very good advice, but I want to extend that idea further to say that you need to see the case through the judge's eyes, which is hard to do. I mean, it requires you to basically get out of your own head to do that. Understand that the judge has a job to do, and their job is to make a decision. Their job is to make a decision and then write the decision. And so what I often tell people is, picture what you want the overview of the decision to look like and work backwards from there. Because what the judge will have done is really figured out what we call the deep issue or the decisive issue. There may be more than one. They'll need to have figured out, if there's more than one, what order they go in, right? So what's the threshold issue? What's the internal logic? Draw me the decision tree. What are the absolutely key narrative facts that I need to understand before I understand anything else about the case? What's the legal framework that I am applying? Once you figure out all of those basic things, because that's what's going to appear in the judge's overview of the decision, then you really know you're seeing it through their eyes, and hopefully you're telling your client's story in a way that feels comfortable for the judge, because what you want to do is sort of shorten the distance that they need to travel from, where the jurisprudence is to where you want your case to land.
I remember in the beginning of the pandemic, we had a fight on Twitter. Well, it's all friendly, of course.
Of course.
With some lawyers about the decision of the Court of Appeal to channel most appeals to be heard in writing.
Yep.
And there was quite an outrage that, that was impairing advocacy, that was impairing parties' rights to be heard. And then, in my opinion, it was totally fine. That was my position. So in your view, what is more important at the Court of Appeal level, written advocacy or oral advocacy?
I'm not going to give you my opinion. I will tell you, what every, John Laskin will, for example, say that the factum gets you through the 7th inning stretch. So pick your sports metaphor. Justice Stratus will say it gets you to the 3rd period of a hockey game. I think we have all heard in all types of CLE that the written argument is comparatively more important. It's not to say that oral advocacy doesn't matter. Of course, oral advocacy matters. It matters in all sorts of interesting ways, not the least of which is, the appearance of justice being done. But there is no question, I don't think there's any dispute, that the written argument is the first impression that you make with the judge, and it's the lasting impression. What litigators really need to appreciate is what they see in court is a judge more or less impassively receiving information in the order in which counsel has chosen to present it. That's not the job. What the lawyer isn't seeing is all the work that the judge is doing to prepare for the case. So, you can imagine how much preparation goes into being able to come to court with that set of X-ray glasses to get right to the point, right? And then all the work that they're doing after the hearing to write the decision. So what the lawyer sees in court represents, in most cases, the smallest portion of time that the judge is spending on the case at all. And I think that what I've seen again and again and again with litigators that I've worked with is that intellectually, people understand that the written argument is comparatively the more important. And yet in practice, they don't give it the time and attention that it's due. So I'll often ask people, when you go to argue the motion or the appeal or the whatever, do you put an out of office on to let people know that you're not going to be available and it's because you're in court? And most of the time people say yes. And then I say, okay, well, when you were writing that factum, did you put an out of office on? No one ever says yes, right? And that doesn't make any sense, because shouldn't you be as singularly focused on writing the written submission, which is more important? And so I really want to encourage people to develop a culture where when the work on their desk is the written submissions to court, that people understand that that is as sort of sacred and protected as, you know, when you are standing up and arguing in court.
I close the email tab when I write my factums.
Exactly right. Exactly right.
I mean, I don't like emailing generally, but especially when I write my factums. So I want to ask you a question that I also asked Justice Myers, and it has to do with the balance between oral and written advocacy. Do you think that such exceptional, extraordinary lawyers exist that they can, at oral argument time, seduce the judge and sort of create this magical combination of personal aplomb, the narrative, the argument, the law, that it will override the judge's first impression, and it will be decisive, and it will make all the difference?
The oral argument definitely can make a difference. Oral argument can change minds. There's no question about it. I would distinguish between those cases where oral argument makes the difference because the written submission was unclear, right? So sometimes the clarifying moments that happen in court were only clarifying because things were unclear before. And those are not the kinds of clarifying moments that you want. So leaving those aside, yes, I think that you certainly can have the experience of bringing your client's story to life in a way in oral argument and in the give and take, you know, with an engaged judge. I mean, there's nothing better than that, right? And to watch the back and forth between an engaged bench and a really skilled lawyer is just, you know, alchemy, you know, beyond anything else that you can see. And so I really understand why people are so eager to get back into court in person to have more of those experiences. But I would also say that I think litigators take their wins and losses really hard, and that's, you know, understandable. And I'm not here to talk anybody out of that. But I think it's important to understand that some cases, the most skilled litigator will lose. And some cases, the most unskilled litigator will win. So, you know, imagine you've gone to argue a case at the Court of Appeal and you're counsel for the appellant, and you get up and you make your argument, and the court retires briefly and comes back and says, we don't need to hear from the respondent, and they issue their decision from the bench. Well, a lawyer can, you know, counsel for the appellant can go home feeling very, very dejected in a situation like that, right? Except I would argue that maybe what that's a sign of is that the written submissions were as clear as they could possibly be. There was no doubt left in the judge's mind. The law just didn't take them where the lawyer hoped, right? And there's only so far you can take that. And the oral submissions were also similarly very, very clear. You know, if there's any doubt, you call on the respondent to hear from them. And so it's, you know, it's possible that that, in fact, while is, you know, obviously a loss and a painful one in the individual case, it might have been, you know, scored as a win for, you know, your reputation for helpfulness to the court. I don't think it's a matter of seduction. I think it's a matter of helpfulness. And if you are maximally helpful in a way that let the judges do their job, then over time you develop a reputation for candor and helpfulness that will serve you. And you know, again, it's not to take away from the idea that you always want the best result possible for your client. But I think we should take a broader view of what it means to be a successful litigator.
You mentioned one written advocacy mistake, not setting up an out of office when you write a factum. What is another huge written advocacy mistake that you constantly see lawyers make?
So I identify what I would call a few unforced errors. And I think the common unforced errors are writing that factum for anybody other than the judge. So who are some of those other audiences? Well, lawyers will often, if you're a more junior lawyer, you're often writing for somebody more senior on the file. And so you're, taking the first crack at it. I think that's an unhelpful way to look at it, because no one really puts their best effort into the first crack. So I think whoever's holding the pen should write as if they are not just the first person to hold the pen, but the only person to hold the pen. Writing for the client is, I think, an unforced error. The lawyer is the expert. So as my grandmother used to say, you don't tell the surgeon how to operate. It's perfectly fine to have the client, sign off on the factum. But in my respectful view, they shouldn't have final say on, for example, what the tone is, because lawyers know better, what kind of tone will fly with the court. And that's not something that you would expect a client, frankly, to know better. And then the most common unforced error is to write the factum for yourself, right? To write it so that you figure out what are the relevant facts, and you're sort of on a journey of discovery of what are my issues. And so a diagnostic for that would be, when do you write your overview? Do you write your overview at the end to reflect the path that you've laid out for yourself? Or do you write it at the beginning because you have it figured out and now you're ready to communicate it to somebody else? I put my thumb on the scale on the latter. You write your overview first because you are now setting out the roadmap for your reader. That's not to say that you don't write the first draft of the factum for yourself to figure it out. But I really strongly encourage people to do that in a separate Word document outside of the template that you use to actually write your factum. Figure it out for yourself. And when you're ready to teach it to somebody else, that's when you open the fresh document and you're ready to communicate to the judge.
I have a question about written advocacy in motions. What do you think about this technique of writing a draft factum before you draft affidavits?
That is a sort of level of detail that I can't speak to. So I'm gonna pass on that one.
All right. So I wanted to bring up Justice Myers again. So when I talked to him in my recent interview, I asked him about the state of lawyers or litigators' competence in general. And, he had some words about that. But I want to ask you about the state of legal writing and specifically about the state of lawyers' competency with respect to legal writing in your experience.
I think we're in a period of transition. I'm pleased that I think we are, as a profession, generally more ready to embrace the idea of plain language. And when I say plain language, I don't mean dumb it down. I don't mean make it simplistic. I mean that there's a sort of formal definition of plain language, which is that in the time and with the effort your reader is willing to spend, they can find what they need, understand what they find, and use what they find to meet their needs. So that's a really robust definition, and that sort of encompasses structure as well as substance and style. I think we, as lawyers, generally are not as effective in our written communication as we are in our oral communication. I think we have a sense that we have to, we don't do a really great job of distinguishing between professional writing and formal writing. I think professional writing is always what you're aiming for, but I think of it sort of like a dress code. So, you want to be dressed appropriately for the occasion. And some of the writing that I see, although as I say, I think this is changing, is not just professional, but, formal, where somebody is not just wearing a tuxedo, but they're wearing, a top hat and a monocle too, right? So it's very outdated. We need to understand that all of our audiences need prose that is easy to read and understand the first time. And that goes for judges even more than for other audiences, because the burden on judges and the amount of stuff that they need to read is so tremendous that they really do need the sort of the shortcut. They need the simple sentence construction, and they need the point first. We all know, point first and transitions between paragraphs and useful headings and subheadings. There's a really, really good study about preferences for plain language over sort of what we would think of as traditional legal writing. And what the study shows is something that seems like a paradox, which is that people's preference for plain language up with education level. So if you read something and you're comparatively less formally educated, you have a higher tolerance for reading stuff you don't understand because you assume that the problem lies with you. If you're comparatively more formally educated and you read something you don't understand, you're more inclined to blame the writer. And so for legal writers, what you really don't want to do is create antagonistic readers. And a confused reader is an antagonistic reader. And so whether it's your client or it's, co-counsel, or it's opposing counsel, or it's the judge, think about what you prefer. What do you like to read? And then practice those same principles when you communicate, because after all, it's just communication with anybody else. So really, it's that basic principle of, do unto others, write for someone else the way you would want to read it.
You mentioned dumbing down when you talked about plain language, and you said, don't dumb down. That's not what plain language is about. Where is the threshold? Is there a line where I will insult my audience?
So what would be an example of something where you would be worried that you'd be insulting your audience?
Well, I do not, of course, mean slang or curse words or things that are completely tasteless, but I am talking about reducing the complexity of sentences to, let's say, young adult novel level or something like that, because I see some materials out there, I see some experts out there, especially in the US. I think the US is really into simplifying things, the US tradition, the American tradition. And they really ask to make things as simple as possible. So there is no bottom, assuming that you remain tasteful, assuming that you do not cross lines into slang or things that are obnoxious. There is no bottom. You can go as far down as possible in simplifying things. Do you think it is risky? Do you think you need to project some level of sophistication in your writing? Or do you think making it as simple as possible is good because they have to read a lot of factums at the end of the day? And if your factum is a breeze, there is no way they will hold your lack of so-called sophistication against you.
I don't see it. I agree with you that you don't want to make something simplistic, right? So you don't want to strip the nuance out of something that requires nuance. You don't, so that's for lack of a better term, because I really don't like it, maybe that's dumbing down, but that's not what we're talking about. What we're talking about is understanding what your reader needs, what they already know, what you need them to know, and what steps you need to lead them through to get them to what you need them to know. That's what a good teacher does. So I don't think anybody accuses a really good teacher of dumbing things down for their students. What a really skilled teacher does is understand the qualities of their students and then meets them, where they are and takes them collaboratively by the hand and takes them on a learning journey. I think that's the goal. So, and when you mentioned reading level, I think it's an important point. There are, when you're finished your Word, your spell check in Word, you will get user readability statistics on your document. If you didn't know that, it's there. And so it will give you a reading level. Those algorithms are only, they're useful, they are a tool. I think that if anything comes back, let's say at a reading level 17, you might want to go back and revisit it, because no one really wants to read at a grade 17 level, even if, functionally, if you add up all the years of expensive post-secondary education, perhaps we are at a grade 17 or beyond. Similarly, and this is an exercise that I run all the time when I teach decision writing, I give people a really, really, really hard to read version of a recipe. And I ran it through, I wrote it and I ran it through a readability score, and it comes in at like a really nice grade 8 level. But it's not useful as a recipe because it's not formatted as a recipe, and it doesn't tell me what ingredients I need first. And it's sort of this stream of consciousness, and I'm the only person it's useful to. So the reading level is only one metric, and it doesn't, really tell the story of how readable your prose is. And then the last thing I'll say on this is some of the best writers, and I often, I commend people to read anything by Michael Lewis, who I think is probably, to my mind, the most effective nonfiction writer out there right now. Read anything by Michael Lewis. It's a pleasure to read. He writes about arcane, seemingly very boring subjects in a, non-gimmicky, but very readable way. I don't think anyone would accuse him of dumbing things down. So that's just an example. And so to the extent that if anybody finds this challenging, read a lot, read widely, and it will sort of start to give you a sense of what good, clear writing sounds like, because there's an auditory element to it, right? It's not just what the words look like on a page, but it's how they come to life in the reader's head.
Caroline, you hosted a series of podcasts for the Canadian Institute for Administration of Justice, and I listened to a few episodes that you dedicated to the brain. Why are you interested in the brain? What does it have to do with advocacy?
So many, many, many years ago, my brother-in-law came over to learn to cook a meal because he wanted to impress his then girlfriend, now wife, my sister-in-law. And he was in his residency training at the time. He was doing a surgical residency. And so when it came time for me to show him how you smash a clove of garlic by putting the knife down flat and smashing it with your fist, he balked. He said, I can't do that because I can't risk injuring my hand. And that really stuck with me, because as lawyers and judges and adjudicators, the only body part we really need is our brains. And nobody teaches us how our brains work. And nobody teaches us how to protect that most important body part. And there is a very strong association with very high levels of burnout and poor mental health, with the way, as it turns out, and this is sort of what I've discovered as I've looked deeper and deeper into this. Our brains don't have an infinite capacity to process information. We don't have an infinite capacity to run on just a persistent state of sleep deprivation. And so on and so forth, to be constantly interrupted, whether it's by, pinging in our inbox or text messages or whatever it is. We're not superhuman, right? We like to think of ourselves as maybe that we are, and because we're very, very smart, our brains can do all sorts of things. But in fact, our brains have limits the same way that all of our other body parts have limits. And so I wanted people to understand more about the neuroscience of how their brains actually work, so that, first of all, they could be more effective advocates on the one hand and communicators on the other. So it's sort of both sides of the lawyer-judge equation. because it does sort of matter what order you present information in and how you scaffold new information and pair it with old information. That's the communication piece. But then also stuff like attention and executive functioning. These are all really important concepts for us to understand, to build and then sustain careers in the long run.
Caroline, you of course offer the wealth of your experience and knowledge through your consulting practice. Talk a little bit about your consulting practice, who the clients are, what services you offer.
So I am that fresh pair of eyes who is going to look at your case. I'm not on your side. I'm not on the other side. I'm on the judge's side. I know how to, prepare a case, read through a record, basically put myself in the position of the person who is going to, be listening to your arguments, asking the questions, because I, for many, many years sat at, as I said before, at the back of the courtroom, listening to the interplay. And so I understand, from working with not just, a few judges, but dozens of judges, how judges do their work. I understand it's a job, and I understand what the job is. And so I will often be brought in on a sort of, high stakes case where, there's, an important jurisprudential issue and, or, something that is very important to the client, which is, any kind of case can fit that bill. And what I do is I moot the case. So this is something that's, really common in the United States. And I don't think we have a culture of this as much in Canada yet. Although, I think some firms sort of do this internally, that they'll pull a panel together. What I bring is, ignorance of your case, but, a sort of robust knowledge of, of the law generally, because that's what a judge is, right? Any judge is a lay reader when they open up your factum. And then by the time they come to court, they're, they really understand your case, and they've read the relevant case law, and they've read the statutes, and, they are ready to hit the ground running, asking questions. And just so people understand, they're asking those questions because they're trying to figure out how they're going to make their decision, right? And so that's what I do in my consulting practice.
Caroline, it's been a great pleasure. Thank you so much for this interview.
Thank you. It's been a pleasure for me as well.